Gentleman, Mr. Marshall.
Point of personal privilege.
Gentleman has the floor.
Mr. Speaker, I wish I had access to the governor to talk to me, to tell me what he thinks about my bill, but he likes to go to third parties. In fact, I was told when this measure was in the subcommittee chairman says, I got a little yellow slip here, says the governor's against it. Didn't say why. There's been no explanation since then. Reference has been made to, will this affect investigations? Well, and that somehow that the first bill was preferred. That bill was not preferred by the governor. And in fact, the word investigation, which was in, I believe, the original bill and the modified measure by the gentleman from Fairfax, was removed because concerns did come up about joint strike force and things like this. The measure that we have from the Senate is limited to one thing: illegal detention. If you want to know what illegal detention is, you reference the code section that are cited in the amendment. Moreover, what is going on here, Mr. Speaker, was acknowledged by President Barack Obama as follows. This is his signing statement on House Bill 1540, the NDAA Act of 2012. The fact that I signed this bill as a whole does not mean that I agree with everything in it. In particular, I have signed this bill despite having serious reservations with certain provisions that regulate the detention, interrogation, and prosecution of suspected terrorists. He says later in here, I will not use the authority granted me to detain people without trial, which must mean logically he acknowledges he was given the authority to detain people without trial. Now, what do we call that? Let's go back to Article 1, Section 9, I think paragraph 2 of the Constitution. The privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. Now, Mr. Speaker, nowhere in the NDAA Act was there any reference to invasion or rebellion. And in fact, while it was referenced here that our two senators voted for the bill, the omission was very interesting because when an effort was made to remove these offending sections, both of our United States senators, and I thank them for this, voted to remove this authority from the bill. That failed. I can't blame them for voting for final passage. There were a lot of things in here that are helpful to our military. But it was sufficient to enough members of our House delegation that while all 11 voted for initial passage of the NDAA, 6 of them voted against it. Of the 7 members of the House, former members of the House of Delegates, 4 voted against it who are now in Congress. It was on the Republican side, 4 in favor, 4 against. Now, Mr. Speaker, let me reference to you some source documents that we have here. Federalist Papers. Alexander Hamilton, number 26. The people of the several states, this is my paraphrase here, ratified the Constitution on the premise that state legislatures will always be, quote, not only vigilant but suspicious and jealous guardians of the rights of the citizens against encroachments from the federal government. Federalist 28. It may be safely received as an axiom in our political system that the state governments will, in all possible contingencies, afford complete security against invasions of the public liberty by the national authority. That's what Alexander Hamilton, who was a proponent of a very strong central government, said. Now, Mr. Speaker, let me read to you some excerpts from one of our colleagues, Congressman Morgan Griffith. This is December 14th, 2011. He says, the bill arguably expands the original authorization of the use of military force, which was enacted in the aftermath of 9/11. I do not believe that the military should be able to exercise the power of detention at home against U.S. citizens. This should be the jurisdiction of the FBI, state, and local police. He further says, when language isn't absolutely clear, Mr. Speaker, and there is an issue of liberty for U.S. citizens, if I am to err, I choose to err on the side of liberty. So, Mr. Speaker, it is our obligation to read statutes in the federal government that affect our citizens. And the deprivation of liberty, the taking of people off our streets without specific charges, without counsel, without trial, is a responsibility that we must bear and only we can exercise at this point. How ironic would it be if, in fact, Congress reversed itself and here this body went on record as favoring violation of the oath of the writ of habeas corpus? We don't care if you're taken off the streets. It's not our concern. This is only national defense. No, it's not national defense. You took a dual oath, an oath to defend the U.S. Constitution and the Constitution of Virginia. Both those constitutions have references to the personal liberty of citizens and due process. If you think back, if you don't think due process is important, will you ask yourself why Christ, when he was confronted with people who wanted to get him to deny the Mosaic Code, the only time it's recorded in Scripture, he bent down and wrote something. And the charge against this woman was adultery, the penalty of which was death. However, what the Pharisees forgot, the requirements of the Judaic law required any offense which had a death penalty part of it to be done in writing. Christ fulfilled the Mosaic law and wrote down, I would suggest to you, the charge against her. When he stood up, he said, now, which of you will throw the first stone? Second part of Mosaic law, you had to have clean hands. Now, how did the Pharisees find this woman in a brothel? I don't know, but they knew. They all walked away. So here is the author of our lives, the author of law, of the moral law, substituting procedural due process, and he wouldn't prosecute this woman. Now, Mr. Speaker, we have to pay attention to our duty to our citizens. If you're going to say do this, this is now this body going on record to suspend habeas corpus when Congress clearly did not follow the requirements for that. When this bill comes up, I urge accepting of the amendment, because the governor never told me, and as a matter of fact, the governor's office told our friend, the chairman from Virginia Beach, he didn't want it. Now, whether this figures into adherence to some person for a political office, for the presidency, I don't know, but our duty is to the common good and to our Constitution first. Thank you.